Disclosure and contract clarity are among the most critical elements of Arizona real estate transactions. Under Arizona law, both sellers and licensees must provide complete and accurate information that could affect a buyer's decision, while contracts must specify detailed contingency terms, conveyance items, and closing requirements to ensure enforceability and transparency. Preliminary Title Report, ARS. Paragraph 20 or 1562-5. A preliminary title report, also called a title commitment, is a document issued by a title insurance company under ARS. Paragraph 20 under 1562-5. It provides a preliminary summary of the property's ownership history, recorded liens, encumbrances, easements, and other matters that could affect title. This report is not a guarantee of title, but an offer to ensure the title once the identified exceptions are resolved or accepted by the buyer. Licensees must ensure buyers review this report carefully to identify potential title defects before close of escrow. Planned Community or HOA disclosures. ARS, paragraph 33, 1805, 33, 1806, and 33, 1258. Under ARS, harf 33, 1805, and 33, 1806, sellers in planned communities or homeowners associations, HOAs, must provide specific disclosure documents to buyers. These include the community's covenants, conditions, and restrictions, CC&Rs, bylaws, current operating budget, annual meeting minutes, and any pending litigation or special assessments. The HOA must provide these materials within 10 days of request, and the buyer may cancel the contract within 5 days of receiving them. For condominiums, ARS PRGARS 33, 1258 imposes similar requirements, mandating disclosure of the condominium declaration, bylaws, management contract, and any maintenance or financial obligations that may affect ownership. These disclosures ensure that buyers understand the community's governance, fees, and restrictions before completing the transaction. Deed restrictions. Deed restrictions are private limitations recorded against property titles by developers or prior owners, often governing use, appearance, or building type. These restrictions run with the land and remain binding on subsequent owners. Agents must ensure buyers are aware of such restrictions, as they can affect future use, renovation, or resale value. Contingencies and contract requirements. Savoca Masonry Co-Burs, Income v. Homes and Son Construction Co. Inca, 1975. This case established that contract contingencies must be written with specificity. Vague or ambiguous conditions can render a contract unenforceable. For instance, a clause stating subject to financing must specify the type of loan, interest rate, and time frame. Real estate professionals must draft contingencies clearly to prevent disputes and protect client interests. Voigt v. Ott, 1959. In this case, the Arizona Supreme Court ruled that fixtures and items permanently attached to the property convey with the sale unless excluded in writing. For example, built-in appliances and light fixtures are considered part of the real property, while personal property, such as furniture or detached equipment, is not included unless stated in the contract. This precedent reinforces the importance of identifying all items to be included or excluded from the transaction. Connor vs. Cal as Properties, Inc. House, 1983. This case emphasized that a buyer's right to cancel a contract based on a contingency depends strictly on the written terms of the agreement. If the contract specifies that a buyer may cancel for a failed financing or inspection contingency, that right must be exercised according to those terms and timelines. If a buyer fails to act within the contractual period, they may lose the right to cancel. Autonumerics, Inc. vs. Buyer Industries, Inc. 1984. This case established that typed or handwritten contract terms supersede pre-printed language when conflicts arise. For example, if the standard form's printed clause differs from what is written or typed in by the parties, the customized language controls. This ensures that negotiated terms reflecting the parties' true intent take priority. Contingencies are vital to protect buyers and sellers, especially in events such as bankruptcy, death, or unforeseen incapacity. If a party dies before closing, the contract remains binding on their estate unless stated otherwise. Agents must ensure all such conditions are clarified in writing to prevent confusion or litigation. Close of escrow settlement statement and closing documents. At closing, a settlement statement, SHUD 1 or closing disclosure, outlines all debits and credits between buyer and seller. Licensees must review these documents to ensure accuracy, confirm that funds are properly dispersed, and verify that all contingencies and inspections have been satisfied before title transfer. Affidavit of Value, ARS. Paragraphs 11, 1133, and 1137b. Under these statutes, an affidavit of value must be filed with the county recorder whenever property is sold. The affidavit lists the buyer and seller's names, sales price, and property location for tax assessment purposes. ARS. Paragraph 11, 1137b requires that the affidavit accompany the deed at recording. This document helps the county assess accurate property taxes and track property transfers. Affidavit of Value Exemptions, ARS. Paragraph 11, 1134. Certain transactions are exempt from filing an affidavit of value under ARS paragraph 11, 1134. Examples include property transfers between family members, transfers through wills or estates, foreclosures, and deeds correcting errors. Although exempt, these transactions must still comply with proper recording procedures to ensure clear title. Recording and the race to record mentality. In Arizona, recording a deed is essential to establish priority of ownership and protection against future claims. The state follows a race notice recording system, meaning the first party to record a valid deed without notice of any prior unrecorded interest holds superior rights to the property. This underscores the importance of promptly recording all deeds, liens, and releases to protect ownership and prevent fraud. The recording process occurs at the county recorder's office, where documents become part of the public record, giving constructive notice to the world of ownership changes and encumbrances. Real estate licensees should ensure all closing documents are properly executed, notarized, and recorded to finalize the transaction and protect the parties' interests